Hi, and welcome to episode 6 of the 2025 update of Elder Law 101. If you haven't been to this series before, my name is Arthur Bergeron. I'm an attorney at Myrick, formerly called Myrick O'Connell. I do nothing but elder law and have for the last 15 years. And the purpose of this series is to really help you understand a whole set of issues that are connected with being old, being a senior, all of the things that you're going through, all the way from before you were old until after you're dead. So we really try to cover everything. So in these episodes, we started off just talking about issues that you would confront if you were under 60, where you're typically not concerned about frailty and things, but you are concerned about what happens if you end up in the hospital, what happens if there's an emergency. We talk about incapacity and other things. We talk about things that have to do with your 60s, when you're in your 60s, when you're retiring and you're going on Social Security, etc. Dealing with your 70s, where you're maybe thinking about slowing down, moving to a different house, getting prepared for things. We did a presentation on income tax basics for seniors, which you should all know about in terms of estate taxes, income taxes, the local property tax, all issues, some of which are unique to seniors. Then we talked about life in your 80s. Today, I want to talk about probably the most common issue that folks talk to me about. Either they are planning to make sure that they are not going to need to have a problem if they need to qualify for MassHealth, the Massachusetts name for the Medicaid program, either because they need nursing home care or they need a lot of care at home in order to avoid going to the nursing home. Or they didn't do any planning and they just show up and they're like, what do we do now? So what I'm here to tell you is that you can always qualify for MassHealth. And by MassHealth, I mean MassHealth long-term care services or the services that you could get at home if you could demonstrate that otherwise you needed long-term care services. I'm going to talk about my friends Frank and Mary and their kids, Peter, Paul, and Mary Jr. And these are the same folks that I've been talking about now for almost a decade. We're going to talk about their situation. Frank, but I'm going to talk about, for asset purposes, I'm talking about them in two different places. One, in Metro West, where I live and where a lot of my clients are. And two, on Cape Cod on the islands. I go to Martha's Vineyard in Nantucket every Thursday. It's Island Day. And I have a lot of clients on the islands. Their situation is a little different just because of the real estate value. So if you're Frank and Mary in Metro West, I'm going to assume that you have a house that is now worth $400,000, which I know is on the low side. But I think that pretty much covers everybody. Frank's has an IRA with $200,000. They have joint savings of $200,000. So they have total assets of $800,000. Frank's Social Security check is $2,000 per month. Mary's is $1,000, or half of Frank's. That's their situation. And the question, and by the way, if they were on the islands, their numbers would be the same, except the house would be worth $1.1 million instead of $400,000. And that's certainly not an unusual number on the islands. So the total value of their assets, therefore, is about $1.5 million. Their income does not change. During this series, I've also talked about Peg and her daughter, Peg Jr., whom she always calls Peggy. And the reason why I mention her is just because if you are single and you're listening to this presentation, I'm telling you that Peg's situation is the same as Frank's wife Mary's situation would be if Frank had died and Mary was single. So I'm really talking about that, the two of them really at the same time. I'm assuming that Peg's situation financially is the same, that she has a house worth $400,000, IRA of $200,000 and savings of $200,000. And if she's on the vineyard, she's got a house that's now worth $1,100,000. So the question to begin with is, if you're Frank and Mary and you've been living your life, and all of a sudden Mary has a stroke, falls down, for whatever reason, she needs to go into a nursing home, what does she do? Can she qualify for MassHealth? Once again, the Massachusetts name for the Medicaid program. Well, interestingly, she can. Almost immediately, and people are always amazed when I talk to them about this because they think, but wait a minute, we have all these assets, we can't qualify. Well, because Frank is alive, Mary can qualify almost immediately. The reason, in order for Mary to qualify, she could own the home, It's not a countable asset. She could have other cash or cash equivalent assets worth up to $2,000. But Frank, as the healthy spouse, can also own the home. He can have assets of up to $157,000, and he can have unlimited income. And if Mary were single because Frank had died, then Mary could qualify for MassHealth if she owned that home, but MassHealth would put a lien on it. If Frank's still alive, however, Mary can simply transfer the house to Frank at the last minute. There is no look-back period regarding transfers between spouses. She can my advice to her would be, because their total assets are they're in money, not the house, is about $400,000, is that she keeps, say, $100,000 of that, or that she transfer all the money to Frank. And by the way, when I say she, if she's had a stroke, she's not going to be able to do this herself. But as we've talked about in previous seminars, one of the key things that you need as a senior, if you're a couple, is a power of attorney. You each have a power of attorney naming the other as the agent, and the agent in that power of attorney has to have the ability to give things, to gift things to themselves. And as long as Frank has Mary's power of attorney so that he, on her behalf, can gift the house back to him, the house is immediately safe. Regarding the money, I would tell Frank, keep, say, $100,000. Take the rest of the money and buy an annuity. And as long as that annuity calls for equal monthly payments over a term that is shorter than Frank's actuarial life expectancy at that time, the purchase of that annuity in any amount is a legitimate conversion from a countable asset to a non-countable income stream. Frank can have infinite income. So the day after Frank buys that annuity, thereby reducing his remaining assets below $157,000, Mary can qualify for MassHealth. Now, we're going to talk about that annuity in a second, but once again, the main thing to remember is that all of this can be done at the last minute. And the reason why Frank would not put, why Mary would not put all, or Frank would not put all the money in the annuity, is because if he were to do that, then he just wouldn't have any money to live on for a while. But by the way, you're looking at these numbers and you may be saying, but wait a minute, if Frank buys this annuity, then very soon he's going to be getting these big annuity checks and he's going to be over the $157,000. But the key to remember is Frank only needs to be under $157,000 before Mary qualifies for MassHealth. The day after Mary qualifies, Frank can hit the lottery, have $1 million, won't make any difference. So the point is, once Frank has bought the annuity, Mary's on MassHealth, her income from pension and Social Security, which here is $1,000 a month, will go to the nursing home. MassHealth will pay all the rest. MassHealth will pay all the rest. Okay, now, what kind of annuity? Here's what kind of annuity. It has to call for equal monthly payments over a term that is shorter than Frank's actuarial life expectancy. If Frank were 80 years old right now, his life expectancy would be around 10 years. He can't have the ability to cash it out early. He can name Peter, Paul, and Mary as the death beneficiaries in case he dies during the term of this annuity, because these payments are going to keep coming during the term of the annuity because it can't be cashed out early. And finally, if Frank does this and Mary qualifies for MassHealth and MassHealth starts paying money on Mary's behalf, like to the nursing home, and Frank then dies before the term of the annuity has expired, whether or not Mary is still alive, MassHealth will have a lien on any remaining payments that have not yet been paid to Frank, which is the reason why we would always advise Frank, well, the term of the annuity can be as long as his actuarial life expectancy. He'll probably want to make it for a much shorter period. Now, once that's happened, once Frank has all the assets and Mary has qualified for MassHealth, then Frank should probably take another step. And by the way, this is a step that Frank and Mary could have taken years before. So when couples come in and say, well, what can I do to protect my assets from MassHealth? What I tell them, if they're a couple, is make sure that each of you does this. He should get himself a will that says that if he dies, any of the assets that he now owns, the house or any of the money, will go, instead of going directly to Mary, which is what his will used to say, will go in trust for Mary's benefit. And any one of the kids could be the trustees of that trust for the Mary's benefit. The trustees would have the discretion to use any of that money at any time to benefit Mary or give it to her. But the point is that any of the money that is still in trust will be safe, non-countable, and non-lienable in the event that Mary needs to qualify for MassHealth. So if Mary is already on MassHealth and Frank has these assets and he dies, and these assets flow through his will into a testamentary trust, a trust that's part of the will, for Mary's benefit, Mary will remain on MassHealth, and these assets will never be subject to a lien even after Mary's death. The next question, though, happens is, what if Frank has died? They hadn't had any of this kind of planning in place. So Frank dies, Mary inherits all of Frank's assets. And now Mary needs to qualify for MassHealth. And once again, if she's on Metro West, she's got this house worth $400,000. She's got all this cash. If she's on Martha's Vineyard in Nantucket, she's got a house worth $1.1 million, and she's got all this cash. What can she do? Well, I guess the first question, though, would be, if Mary had not needed MassHealth right now, what could she have done? Well, and by the way, all of Mary's strategies are the same as the strategies that would have applied to Peg and Peg Jr., also called Peggy. That is, if you're single, then here's the strategy for you. What you would want to do, this is your asset protection strategy. If you're single, you want to give all of your assets away and wait 5 years. That's the famous 5-year look-back period. Regarding your home, what you probably want to give away is not the entire interest in your home, the so-called fee interest in your home, but rather a remainder interest in your home. That is, the interest that starts after you die. Mary would keep a life estate in the house. That is, the interest that lasts while she is alive. 5 years and a day after she's transferred that remainder interest, it would no longer be countable or lienable in the event that she needed to qualify for MassHealth. And remember, and if you haven't seen the earlier presentations on this, there are no gift tax consequences to any of this, because there really is no gift tax, and I talk about that in these other seminars. So that's so she needs to be giving the property away, and anything that she gives away is not income to the recipient. It wouldn't have to get declared on the recipient's income tax return. So who should she give it to? Well, she could just give it to her kids. She could give her remainder interest in the house to the kids. She could give all the money to the kids. And often that's what Mary would do if she only had one child and she was going to give everything to that child anyway, and she trusted the child. Then what she could do is she could give her away all of her assets. And 5 years and a day after she had given them away, those assets would no longer be countable or lienable if she needed to qualify for MassHealth. If she had multiple children, then often her strategy instead will be to create an irrevocable trust. Irrevocable means whatever you put into the trust, you can't take back out of it. So it is as if you have given your property away. She would name her most trusted child as the trustee of the trust. She would, by the way, keep in her discretion the ability to get rid of that most trusted child if the child didn't work out. She would not have the ability to make any distributions, to order any distributions to herself. The children would be the beneficiaries. And she would only do this, as she would have only given away the assets to the one child, if she trusted that trustee, if she trusted that in that situation, if she needed the money back or she needed home care or whatever, that the trustee would transfer the money back to himself or herself or to one of the other kids, and the kids would in turn give the money back to their mother or use it for their mother's benefit. And the trust would also say that following the mother's death, whatever was left in the trust would be divided up among the children. As long as she structured things this way, then there would be no lien on any of these assets if Mary later needed to qualify for MassHealth. So Mary can take those estate planning steps. The real question, though, is what if she didn't? So what if Mary is single, and so she can't give the assets away to her husband, but she just had that fall, and now she's in the nursing home, and the kids come to me and they say, well, oh my God, what do I do? Mom's got all these assets. Remember, those are the assets adding up to $800,000, right? If she's in Metro West, and now she's in a nursing home, and she's pretty concerned because she knows the price for private pay in a nursing home, this is on the low side, is certainly no lower than $16,000 per month. And so, for example, if Mary were in that nursing home for 48 months or 4 years, right, her total nursing home bill would be $768,000. During that time, she would have been collecting Frank's Social Security check because he was dead, and when he died, she got to start getting his Social Security amount. So she would have collected and paid to the nursing home 96,000 of those dollars, but all the rest, $672,000, would have needed to have gone to paying for her care. And of course, she doesn't have $672,000. A lot of her money is in the house, which means in order to get that money, she would have had to have sold the house. She may or may not have owed a capital gains tax, but the point is that in Mary's case, at the end of those 4 years, if she owned that property in Metro West, at the end of the day, if she died at the end of those 4 years, she'd only have $128,888 left to give to the kids. If she was on the islands, only because the real estate was worth more, she'd have $828,000 left to give the kids. So the question is, in that case, should Mary go and qualify herself for MassHealth anyway? Well, here's why she should. Once she's qualified for MassHealth, then that same bed in that same nursing home that was charging her about $16,000 a month is going to be about $8,000 per month. Assume that the nursing home cost is that $8,000 a month for 4 years, total $384,000 minus Mary's income, which is the same if she qualified for MassHealth. As I mentioned, her income goes to the nursing home. So that's minus 96, which means that the amount on which MassHealth would need to get repaid after Mary's death, because Mary, for reasons I will explain, MassHealth would have a lien on her assets to get repaid after her death. But the amount would only be, in Metro West, $800,000 minus that $288,000, or $512,000. On the islands, in either case, it would only be $288,000. Which means on Metro West, she'd have $512,000 left. On the island, she'd have $1,212,000 left. That's why Mary should be trying to qualify for MassHealth. The point is that she can. Mary can qualify as a single woman, or her sister Peg can qualify as a single person. By putting the money before she applies for MassHealth, and this can be done the day before she applies for MassHealth, by using one or two planning tools. One, putting the money into a so-called D4C pooled trust. What in the world are those? D4C is the last three initials of the section of the federal law that created Medicaid that allows this to happen. These pooled trusts are operated by nonprofit organizations for the benefit of seniors and disabled people. If you want to learn more about them, you should just Google the term pooled trust, P-O-O-L-E-D, or Plan of Massachusetts and Rhode Island. That just happens to be the pooled trust that we deal with the most. But basically, what the pooled trusts do, right, is that they would take Mary's money or assets, pool them into this big pile of money, together with all of the other money that they're managing. That's why this is called a pooled trust. These assets, they would invest them. They would charge a management fee of like $1,000, 1% a year, typically not that far from your typical management fee. And then following Mary's death, they would have a claim on some of those funds. But the point is that from Mary's perspective, she can transfer these assets out to the pooled trust, and they're not countable, and there's no lien. And they can be used for anything that would benefit Mary while she's alive. There would be a lien on any remaining funds following Mary's death. But while she's alive, these funds can be used for anything that might benefit her. This is pretty much the typical cost of the pooled trust, is between $750 and $2,000. Annually, they're typically charging about some percent, between 1% and 2% of the value of the assets that they have under management. Their final fee is 5 to 25% of the amount that she has remaining. These pooled trust funds can be used for any number of things. In Mary's case, the main thing to focus on is they can be used to maintain the house. Remember, the house, as I mentioned way at the beginning, is not a countable asset, right? So except that when Mary becomes a MassHealth, gets to be on MassHealth, MassHealth will put a lien on the house, and MassHealth's going to be entitled to get repaid following Mary's death, but she does not have to sell the house. The problem typically, though, is once she's on MassHealth, how does she maintain the house? She has no money, right? Because all the money is going to the nursing home. Well, the D4C can actually pay for the taxes, the insurance, all the costs for the upkeep in the house. They can also pay to buy better equipment for Mary, or better furniture in the nursing home, or physical therapy, or food that can be brought in, any number of things that could improve Mary's life at the nursing home, right? Now, once again, once Mary is dead, or MassHealth's going to have a lien on any remaining money in order to get repaid, but there's more of a chance that there's going to be some remaining money because it was in the pool trust and didn't get all absorbed by paying the nursing home. Second, Mary could buy an annuity. An annuity like the one that Frank bought when Mary was in the nursing home and everything got transferred to Frank, and then he needed to buy an annuity to convert the asset from a countable asset to a non-countable income stream. Mary can do the same thing with some of her money. She can buy an annuity with it. The basic rules of the annuity. We already talked about this regarding Frank. The annuity has to be irrevocable and unamendable. It has to call for equal monthly payments, and it has to be for a term shorter than Mary's actuarial life expectancy, which at age 80 is 10.1 years. MassHealth will have a lien on any remaining payments that haven't been made to Mary after she dies. So if I were dealing with this case, and Mary came in, or Peg, I would or not Peg because she's in the nursing home, or Mary because she's in the nursing home, but the kids. What I would suggest is the way she might want to think about this is she may want to be purchasing an annuity. Remember, once she's on MassHealth, the MassHealth rate on the bed is going to be about $8,000, and the rules are Mary pays all of her income to the nursing home. MassHealth pays all the rest, but then MassHealth has a lien on Mary's assets to collect all the rest after she dies. So suppose in this case that Mary buys an annuity for $6,000 a month, enough that together with the $2,000 a month she has in Social Security will fully pay the $8,000 a month that she owes to the nursing home, so that every month there is going to be no new MassHealth lien because all of Mary's bills to the nursing home have been paid. She then takes the rest of the money, the $122,000 that she has out of the original $400,000, and puts the money into the D4C so that money can be used to pay for any kind of extras that Mary may need while she's in the nursing home. As I mentioned, if Mary dies at the end of those 4 years, there is no remaining lien either on the house where MassHealth had a lien or on the D4C pool trust money. I'm just mentioning this problem because it is a problem kind of unique to the islands. The problem here is that under current law, Mary can keep the house while she's in the nursing home as long as she says on their application that she intends to return to the house, even if there's no chance that she can really return to the house, except that there's a cap on the equity in the house. And that cap is now a little over $1 million. So this strategy won't work for Mary on the islands unless she can get her equity below that $1 million. One way that people will sometimes do that will be by taking out a reverse mortgage, either from a reverse mortgage company or from their kids, right? And basically borrowing the money from that reverse mortgage so that her equity ends up going below the magic number that will allow her to use this strategy. So I know this is a lot of information. If you want to learn more about any of this stuff, you can always go to Frank and Mary's YouTube channel, or you can follow us on Facebook. The goal of the exercise here is peace of mind. As I tell clients, you get to our age, I just turned 75 this year, and fame and fortune has passed you by. You just want to get a good night's sleep. So if any of this is bothering you, check out the website, or check out Myric's website where these presentations are also posted, or you can give me a call at any time, at 508-860-1470. Thank you very much, and I hope you enjoyed the presentation. Thank you.